Hi, I'm Mike with Cashion Legal, and in this video, I'm going to break down 5 things every small business owner in Alberta should know about injunctions. Injunctions mostly come up in the employment law context when you have an employee who's left your business and has started either working for a competitor or if they've started a competing business. If this was a particularly valuable employee, like if they were a successful salesperson or if they were a senior manager or executive, this might cause you serious concern because you think that they might do serious damage to your business by competing. So with that context in mind, I want to go through 5 things that every small business owner should know about injunctions in the employment law context so that you have a better understanding about whether this is something that you can actually pursue in these situations. Point number 1, injunctions are very expensive. In order to obtain an injunction, you need to provide the court with very serious and compelling evidence about the strength of your case. You also often need to do this within a very short timeline, and because of these factors, obtaining an injunction is usually very expensive. In fact, just the first step of the process, actually obtaining the injunction itself, will likely cost well into the tens of thousands of dollars. And that's just the start of the process. There's usually many significant costs associated with the steps that occur after the injunction is granted. So for that reason, if you are considering obtaining an injunction, you should evaluate what the total loss you expect to suffer is, because if it's not significant, then it may not warrant even exploring this potential remedy in the first place. The second thing you need to know about injunctions is that you need to act quickly in these circumstances. In order to obtain an injunction in Alberta, you need to demonstrate to the court that you will suffer irreparable harm. This is a legal standard that means that the harm that you're going to suffer without the injunction is something that cannot be compensated by money. One byproduct of this requirement is that you generally have to move very quickly in order to demonstrate to the court that the injunction is absolutely necessary in the circumstances. The rationale is that if you didn't move very quickly, it's kind of hard to prove that the harm that you're going to suffer would be irreparable. The third thing that you should know about injunctions is that sometimes you can obtain one without giving notice to the other party. Generally speaking, in legal situations, you do need to give people notice of the relief that you're seeking against them. This is just a basic principle of fairness. If you're trying to get something from someone else, they should have the opportunity to be notified of it and present their own case or version of the events. However, the courts have recognized that in limited circumstances, injunctions will not serve their purpose if the other party is notified of the relief that you're seeking before it's granted. This is particularly the case if you're trying to protect the misuse of confidential information, freeze assets, or seize evidence. So in these scenarios, sometimes you can obtain an injunction without notifying the other party of your efforts. However, there are certain guardrails that the court has put in place for these processes, so you should only do this if it actually is suitable for the circumstances that you're facing. The fourth thing you should know about injunctions is that you do not need to go through trial in order to get one. Injunctions are often granted on an interim basis, which means that the court puts this remedy in place while the action is pending. So while people usually associate legal action with long, drawn-out processes, in some situations, you can obtain an injunction within a few weeks that will provide you with an interim remedy while the underlying issues are litigated. The fifth thing that you should know about injunctions is that you should only obtain one if it's absolutely necessary in the circumstances. When you obtain an injunction against a party, you have to sign something called an undertaking as to damages, which means that you are agreeing to pay for any losses that the other party suffers as a result of your obtaining the injunction if the injunction is determined to be improper at a later date. This creates significant exposure for the party who has obtained the injunction. For that reason, we only advise people to obtain injunctions where it's absolutely necessary to do so, because the negative consequences of obtaining an injunction that's not necessary can be very significant. As I said at the beginning of this video, I'm Mike with Cashion Legal. We're an employment law firm based in Calgary, Alberta, and we provide advice to both employers and employees on injunctions in Alberta. If the content of this video is applicable to your small business, or if you're looking for advice on another employment law issue, do not hesitate to click the link to our website and book a case evaluation with our office today.